Test. Okay. We have audio and, well, thank you everybody. Welcome to the Standing Committee on Economic Development and Environment. We are here today in the Sawtooth region. It is our honor and privilege to be here and listen to the people of the Sawtooth. We respect that there are a number of different Indigenous peoples in the Sawtooth region, so thank you once again for having us here. To get things started off, I'd like to ask Charles McNeely if he could start us in a prayer. So I'll ask everybody to rise, and if Michael, you can get Charles a microphone.
Yeah, usually when we have a tradition like we usually open with a prayer to kind of for guidance. So that's what I asked for today, and we'll start off with the Lord's Prayer today. In the name of the Father, and the Son, Holy Spirit, Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Amen. In the name of the Father, and the Son, Holy Spirit. Amen. Thank you.
Thank you, Charles. Very much appreciated. All right, so once again, I want to welcome everyone to our meeting. To get things started, I'll do some introductions. On the far right is Herb Nakamayak, MLA for Nunakput. Next to him is Kieran Testart, MLA for Cam Lake in Yellowknife. Then we have Kevin O'Reilly, the MLA for Frame Lake, also in Yellowknife. We have, of course, the one and only Danny McNeely, the member for Sawtooth and also the deputy chair of this standing committee. And then we have RJ Simpson, MLA for Hay River North. On the far left is Michael Ball, our committee clerk. On our far right is Stephen Dunbar from our research division, and then we also have with us from our public affairs and communications, Chris Cartwright. And so, if you bear with me, I would like to start with some opening comments. Today, the Standing Committee on Economic Development and Environment is holding our public hearing on Bill 38, Protected Areas Act, Bill 39, the Environmental Rights Act, and Bill 44, the Forest Act. The Standing Committee on Economic Development and Environment is a committee of regular members of the Legislative Assembly. The bills we are reviewing today were introduced by the government. They were given first and second reading in the Legislative Assembly and then referred to this Standing Committee for review. This Standing Committee provides oversight on a number of the departments that government, or in particular Cabinet, oversees. And so today, for example, it's the Department of Environment and Natural Resources under the Minister of R.C. McLeod that these bills, they have presented these bills, and it is our duty as a committee to provide oversight and do review of these bills. And so we're happy to be here and take these bills out on the road to get your opinions. The Standing Committee is obviously holding public hearings on these bills in the communities of Fort Smith, Katlodichi First Nation, Hay River, Fort Providence, Betchico, and Nuvik, today in Norman Wells, and before holding our final meeting in Yellowknife. And then we will report back to the Legislative Assembly on the proposed legislation during the upcoming August sitting of the Legislative Assembly. It is our responsibility as a standing committee to consult with residents of the NWT on what they like or don't like about these bills. We would like to hear your views and comments, which will be used by the committee to identify any changes we would like to see made to the draft legislation, and which we will then report back to our colleagues in the Assembly. I wish to briefly describe the intent of these bills. Bill 38, the Protected Areas Act, proposes to establish new legislation that will allow the GNWT to create permanent protected areas in the NWT where there are important plants, animals, land, cultural or historical sites. It also allows for co-management of a protected area with an Indigenous government or organization. This bill says what is allowed to happen in protected areas and what is not allowed. mining exploration, oil and gas development and exploration, and energy developments are prohibited. Small-scale renewable energy projects may be developed within a protected area or by an adjacent community. Roads or power lines may be permitted with consultation of the protected areas management boards. Bill 39, Environmental Rights Act, proposes to change the existing legislation by protecting people's rights to a healthy environment, help ensure the GNWT always considers how the environment could be affected, and investigate when a person reports to the minister that someone has harmed or could harm the environment. Gives residents of the NWT tools to help the GNWT protect the environment, and the GNWT must write a report every 4 years on the state of the NWT's environment, which will be reviewed by the Legislative Assembly and allow time for public comment. Bill 44, the Forest Act, proposes to establish new legislation that will provide tools for and license, allows the GNWT to create rules around harvesting timber and create rules on burning outside communities, allows the GNWT to create rules for harvesting of other forest resources such as berries, mushrooms, and other plants, respond to insects, invasive plants, and forest diseases. For those, most of you I did see helped yourself already to some of the information that we have here, but there are copies of the bills and the plain language materials on the table that we have at the rear. So if you haven't already, I encourage you to help yourself. If you haven't also already, let Michael Ball, our committee clerk, know that you're going to speak today, then please do so. I am aware that we will have Charles McNeely, the chair of SSI, speaking today, and he'll do that in a moment when I call the speaking order. We also, I want to advise people that we accept written submissions, so we will be accepting those technically up until May 3rd at 5 p.m. And so if you have additional information and or a written submission that you'd like to share with us with regard to any of these bills, we would gladly accept those. One final piece of housekeeping, please remember that all submissions will be part of official committee records and may be reflected in our final report. Any submissions made during this meeting may also be televised, or in this instance today we're being broadcast via social media. So thank you everyone for your patience in allowing this introduction. With members' agreement, we can now open the floor to comments from the public. Do members agree? Thank you, members. And without further ado at this time, I will ask Charles McNeely, the chair of SSI, who I have noted in advance was not willing, but is here today to speak on the bill. So if I can get a microphone over to Charles. Thank you, Charles.
Okay, thank you. I just going to do a little bit of opening comments, remarks, and then I'll leave it to Orlina to read our submissions. Okay, I'd just like to welcome you and to be here with you today. Like I said, there's myself as SSI chair, Orlina Modest as our executive assistant, and then we got Brenda Baton that's sitting in also. Okay, I'm pleased to make this presentation to the Standing Committee on behalf of SATU Secretariat Incorporated. The bills 38, 39, 44 were developed collaboratively by the Technical Working Group comprised of representatives of GNWT and SSI and other indigenous governments and organizations that are party to the Northwest Territorial Lands and Devolution Agreement. Okay, maybe I'll get Orlina to do the background and stuff like that.
Hi, my name is Orlina Modest. I'm the Executive Director with the SATU Secretariat. Just some background, the GNWT and SSI and other Indigenous governments and organizations agreed to transfer the administration and control of public lands waters, oil, and gas and minerals in the Northwest Territories in accordance with the Devolution Agreement. As partnership underlies the Devolution Agreement to ensure that public lands and resources are managed in accordance made in the North, legislative that incorporates the principle of co-management and integrates the co-management boards, councils established to pursuant to the Sato Dene Métis Comprehensive Land Claim Agreement. And as well as with other land claim agreements with the Northwest Territories. As part of the Devolution Agreement, the SSI and other Indigenous governments and organizations signed the Intergovernmental Agreement on Lands and Resources and Management. Among other matters, the parties agreed in the Devolution Intergovernmental Agreement to jointly develop the new territorial legislation to replace territorial resources management legislation that mirrored the federal legislation related to public lands, waters, oil, and gas minerals in the Northwest Territories that was repealed on the date that the Devolution Agreement was brought into legal force in 2014. This assured the SSI and other Indigenous governments that the organizations that their role in the development of new resource management legislation would be more than consultation. More than 2 years ago, the GNWT and the representatives of the SSI and other Indigenous governments and organizations established the working group as a formal mechanism for Indigenous governments and organizations to provide input in scoping, developing, and proposing drafting instructions to replace or amend certain territorial legislation, including the enactment of the new Protected Areas legislation, the consolidation of the Forest Management Act and the Forest Protection Act, and amendments to the Environmental Rights Act. In general, the working group worked constructively and effectively where it had sufficient time to complete its policy discussions and review of the bills. For each bill, the working group developed a legislative framework overview table that identified the issues and tracked progress of the discussions. In most cases, the working group reviewed drafts of the bills as they were prepared in accordance with the table. Reasonable compromises were made to address the parties' respective interests. The participation of the SSI representatives and the Indigenous governments and organizations in the working group were not intended to discharge or fulfill the GNWT's constitutional obligation under Section 35 of the Constitution Act 1982 to consult with respect to the bills. This consultation today fulfills in part the federal government's constitutional obligation. The SSI supported the work with the working group and proposes that an independent third party be retained to undertake an audit of the work of the working group. This audit should include the views and perspectives of the members of the working group and take into account the outcome of the legislative process with respect to the bills to ensure the future work of the working group proceeds in an effective and efficient manner. This audit would serve to inform the ongoing work of the working group with respect to the development of amendments to the Waters Act and various regulations under the bills.
You're doing very good.
SSI's approach. In the development of the bills, the SSI took position that their government-to-government relationship with the GNWT must underlie the new resource management legislation. The new legislation must be based on partnership of co-management of public lands and resources. Therefore, key objectives of the new legislation included in the integration of co-management boards, councils, established under land claim agreements and other authorities, and the role of Indigenous governments and organizations in the NWT's management regime. In many cases, the bills provide key elements of their respective management regimes that would be developed or implemented by way of regulations. For instance, Bill 38 establishes a general framework for establishment and management of protected areas, and the Commissioner has broad authority to make regulations about key issues with respect to protected areas. Therefore, the SSI and other Indigenous governments and organizations maintain that they must have sustainable role in the development of regulations under the bills in a manner consistent with the operation of the working group with respect to the development of the bills. It is not enough for the GNWT to simply consult with SSI about the draft regulations. To that end, the Indigenous governments and organizations are developing a proposed agreement for GNWT with respect to the establishment of a body similar to the working group that would be activated from time to time to develop regulations under the Bill 38 and other legislation. Bill 38 Protected Areas Act. The working group established Bill 38 to ensure that Indigenous governments and organizations are involved sustainably in the nominations, approval, and management of protected areas in the Northwest Territories. The SSI supported the introduction of Bill 38 so that protected areas such as Testa, also known as Ramparts River and wetlands, could be established under its provisions as soon as practical. Before a candidate area is established, the GNWT must make best efforts to enter into an establishment agreement with the affected Indigenous government or organizations identified by the Cabinet. Bill 38 lists the various subject matters that may be included in an establishment agreement. We point out that section 17.2.6 of the Land Claim Agreement, the Sawtooth Land Claim Agreement, also lists subject matters that may be part of an agreement related to the administration, management, operation of a protected area. While it arguably that the land claim agreement would prevail to the extent of the conflict or inconsistency between the provisions of the land claim agreement and any territorial legislation, including Bill 38, the SSI seeks assurance that the subject matter identified in section 17.2.6 of the land claim agreement will be addressed in an establishment agreement made under Bill 38. The minister is required under Bill 38 to notify the Sawtooth Land Use Planning Board before establishment of a protected area in the Sawtooth Settlement area and provide description and boundaries or a map of the area. The SSI maintains that Bill 38 must also direct that notice be provided to the Sawtooth Renewable Resources Board or the affected Renewable Resources Council before a protected area is established. Such as notice would include a description of the boundary or a map of the area, or with respect to a change or a deregistration of a protected area. The SSI urges the Standing Committee to give full consideration to our comments with respect to Bill 38 and confirms its support for enactment of Bill 38 as soon as practical. Bill 39, Environmental Rights Act. Bill 39 would modernize existing legislation and the SSI supports the proposed amendments, including measures to enhance investigations, clarify the right to a healthy environment, protect and provide protection for employees who are whistleblowers. Bill 39 requires the Executive Council to prepare a statement of environmental values, requires departments and certain public bodies to consider that statements in their decision making. The SSI and other Indigenous governments and organizations must be involved in the development of these statement of environmental values. Bill 44, a Forest Act. The SSI has two fundamental concerns with respect to Bill 44. Firstly, Bill 44 fails to modernize and update the existing provisions of the Forest Management Act and the Forest Protection Act. As an example, the provisions under Part 6 of the bill related to appeals are woeful and inadequate and out of date. Secondly, Bill 44 fails to integrate the co-management regime for the Northwest Territories set out in the land claim agreements. Its preamble recognizes that land claim agreements create renewable resources boards and provisions for the use of management of forests, and confirms the commitment of the GNWT to work in a collaborative manner within the forest management process. The preamble refers to Indigenous traditional knowledge. However, provisions of Bill 44 fail to address these matters. The land claim agreement sets out specific roles and powers for co-management boards and councils with respect to forest management. Bill 44 fails to integrate these roles and responsibilities and coordinate them with the GNWT's management regime. The roles and responsibilities of the Sato Renewable Resources Board and the Renewable Resources Council under the Land Claim Agreement include the following. The SRRB has the power to approve forest conservation and forest management plans and policies within the Sato settlement area. The GNWT is required to seek timely advice from the Sato Renewable Resources Board with respect to policies respecting forestry and forest management research and the evaluation of such research and plans for training of the Sato Dene Métis in forestry, forest management, and lumbering. The affected Renewable Resources Council must provide consent for commercial harvesting of trees that would significantly affect the wildlife harvesting of the Sato Dene Métis. The Sato Renewable Resources Board may review the decision of the Renewable Resources Council that did not provide consent for commercial harvesting of trees and may permit such harvesting if the Sato Renewable Resources Board determines that it was reasonable to do so. Bill 44 also fails to identify and promote opportunities for collaboration and coordination with Indigenous governments and organizations, including the following. Bill 44 must provide elaboration in Section 7/1 to confirm that the minister will work with the Indigenous governments and organizations and the land claim boards and councils to develop and implement plans, policies, and programs in a manner that promotes an integrated and adaptive approach to the sustainable forest management. Bill 44 must provide that the minister may authorize an Indigenous group or organization or an officer of an Indigenous group Under Section 7-3 to perform the minister's duties or exercise the minister's powers. The supervisor is not directed under Bill 44 to engage with Indigenous governments and organizations with respect to any actions that may undertake to manage, control, or dispose of invasive plant species, forests, insects, or disease. Bill 44 fails to acknowledge that the minister may enter into agreements with Indigenous governments and organizations with respect to sustainable use and management of forests. Bill 44 does not require the GNWT to engage with Indigenous governments and organizations with respect to the disbursement of funds from special purpose funds established under Bill 44. There must be good coordination with Indigenous governments and organizations with their settlement lands, with the GNWT's funding for forest renewable activities. It is not acceptable for the GNWT to simply say that the provisions of the land claim agreements would prevail over any forest legislation, or that the GNWT's forest legislation is subject to the land claim agreements, and therefore the forest legislation does not need to address these matters. There is not consistent with the Bill 44's preamble to integrate the co-management boards and councils established under the land claim agreements and their authorities to provide a role for Indigenous governments and organizations in GNWT's management regime. The SSI submits that Bill 44 requires substantial amendments before it's enacted, and therefore recommends the working group be directed to continue its work with respect to the development of new forestry legislation. Next steps in the legislation process. Given the unique nature of the collaborative process to develop the bills, it may be appropriate for the SSI and other Indigenous governments and organizations to be provided an opportunity to participate in the discussions of the committee of the whole as witnesses, to make submissions or comments about the bills and the process employed to develop them. SSI may ask for your support in request to and support if such a request is made. In closing, the SSI intends to provide written submissions to the Standing Committee over the next week or so. This written submission would address any questions or issues raised by the Standing Committee. Merci.
Thank you. Thank you very much, Orlina. Really appreciate the amount of detail and the substantive submission that you made today on behalf of SSI, and thank you to Charles McNeely for your introductory comments. I'll get you to hold on to the microphone just for a moment, and we'll check here with committee members to see if there are questions or clarification that they would like to raise with the presenter. Oh, and just if we can, we would love to get a hard copy or a digital copy of your speaking notes whenever you can make them available, and please provide them to our clerk, Michael Ball. But with that, I will start with Mr. Testa.
Thank you. Thank you, Mr. Chair, and thank you for your presentation. We were just speaking over reflecting on the last couple of days, and some of the committee members and I were having a conversation, and we reflected that we've probably learned more about the Intergovernmental Council and the technical working group in the past 5 days than we have in 3 years. So it's really, this is important work. And I think we're all coming to appreciate the great value towards reconciliation that that the technical working group and the Devolution Agreement represents, which is why the concerns you've raised around Bill 44 in particular, the Forest Act, have me very concerned. And I was concerned previous in the legislative process at second reading of the House. Many of us spoke about the bill and the concerns that have been raised, and I'm hearing more concerns now. And I just wanted to clarify one point of your presentation. You mentioned, I believe you mentioned the bill should go back to the technical working group. Bill 44, rather, the Forest Act. Is that correct?
Yeah, our comments was that it requires more amendments, and we don't think it's ready to be enacted and amended this soon, and it should go back to the working group for more discussion or more work to be done before it's passed.
Thank you for that clarification. So, this committee has the ability to amend legislation with the consent of the minister. Do you feel that if we were able to address all of these concerns through legislative amendments in the committee process, do you feel that would be sufficient to kind of correct the deficiencies in the bill, or is that not really the point? Is the point getting it back to the working group and where it belongs?
Yeah, I think there's more amendments that need to take place before it's finalized, and I think going back to the working group would be more appropriate at this point.
Thank you very much.
Thank you. Next, I have Mr. McNeely.
Thank you, Mr. Chair, and thanks for your presentation there. And I just want to expand a little bit. Okay, you've made your presentation, and what is going to happen, so that we all leave today with a clear understanding how these processes work for enactment or creation of new laws. And as the chair had mentioned, that take Bill 44, for example, okay, it went through first, second reading, and now the committee is taking out on these community consultation trips here to hear your feedback. And we know that we had several presentations in unsettled land claim regions, like Fort Smith, for example, Hay River, the reserve and the town side. So we heard from those clients and those leaders. Then we went to Bichiko, and we now are into settled land claim areas. And you make reference to the provision of your land claim. And it's the same thing what we heard yesterday from the Inuvialuit Regional Corporation through the Inuvialuit Game Council. So now these presentations here would come to us. We would do our report, and in the report would be your concerns that were addressed and suggestions. So that's where it would end up. Then the report would go to the Legislative Assembly. So I just share the process with you, so that you can leave here knowing that your suggestions are taken seriously. So, thank you.
Thank you, Mr. McNeely. To that, Orlina, if you care to comment.
Thank you for the opportunity to speak. I just want to point out that we've been heavily involved with the technical working groups and with all legislation reviews, along with the other Indigenous governments and organizations since we signed on to devolution. So there's a lot of work that we put into the work that we've been doing, being a part of the process. So I just thank you for the opportunity to speak today.
Thank you. Next I have Mr. Simpson.
Thank you, and thank you for the very detailed presentation. I appreciate it. And like the first the first member stated, we've learned a lot on the road about the process that led up to this development, and I learned a couple new things today from your presentation as well, so I appreciate it. So far, we've heard from the Métis Nation have said they want this to go back to the working group. Kaludice has said they wanted to go back to the working group, and now SSI has made the same recommendation. Unfortunately, the only way that's going to happen is if the bill is defeated in the House, or if it dies on the order papers. So I believe that would be next Assembly is the earliest that the process could start going again. And so if you'd like that to happen, I guess it might take some lobbying of MLAs on how to vote. The issues that you raised were quite numerous and they're quite technical. And I don't think that this committee has the capacity to make those amendments. And that is why the submission stated that it should go back to the working group, because it's a big bill and there's a lot of places where we would have to include these amendments, and I don't think we could do it. And so it would be I don't want to get anyone's hopes up that we can make those amendments that you requested, but given that, if you have very specific wording that you'd like to see in specific sections, we would appreciate those submissions as well, because I know I asked the same thing of the Tlicho, and they're going to provide that to us, and that would be a big help to us, because it's basically us here at the table who have to make these amendments. We have the assistance of a law clerk, but that's it, right? We don't have a lot of capacity ourselves, and none of us are lawyers. So any assistance we can get would be appreciated. Thank you.
Hi. Yeah, we are providing a written submission in the next week or so, but you'll get a copy of our presentation as well.
Okay. Thank you very much. It's well appreciated. Next, I have Mr. O'Reilly.
Thanks. I want to thank Charles and Orleana for the presentations. I just want to let you know that we're of course regular MLAs. We're not in cabinet, and the first time we saw these bills was usually the day before, they would be read one day in the House. We would get them, and then it would get read the next day, and that was an opportunity for some of us to make some very quick comments, and then they went to committee. That was the first time we saw the bills. So we have not received any information about any of the work that you guys have done in the working group, but we're very interested in hearing about that and want to thank you for sharing that experience with us. I just want to reiterate what my colleague Mr. Simpson said, that you've given us a few specific examples of where you want to see co-management incorporated into the bills, but the more specific you can get, the easier it is for us to try to make those changes to the bill. And I'll give you just a couple of examples. The kinds of things that normally happen, or you would think would happen, are notice. That co-management body would at least get notice of a decision by a minister, or a draft of a document, or a plan, or a policy, or whatever. That's one thing, but consultation is another thing that could be required. So, and I'll just give one example. In the Protected Areas Act, the Renewable Resources Boards are supposed to get notice of a nomination. Well, why would minister not be required to consult with the Renewable Resources Board? That could be something that could be added to the bill. But I guess what I want to encourage you guys to do is to think about how you want to get your co-management bodies and Indigenous governments written into the bills, so that it's much more of a co-management process. So the more specific you can be, the better, the easier it is for us to try to make those changes and try to work with the minister to get it. But if we can't get it, there are other options. We could vote the bill down. The minister could actually withdraw the act at any time and say, you know what, these need more work. We're going to take it back to the working group. So there are some options there, but the more specific you can be with the changes you'd like to see, the harder we can work to try to get those changes done as well. Thanks.
Thank you, Mr. O'Reilly. Next, I have Mr. Nakamayak.
Thank you for your prayer and your submission. After listening to what you have to say about these bills, it seems that you have a direct access to the minister, to the department, After the second reading, it seems that the department will actually work with Indigenous groups on the drafting, on the terms, and that I think that might be a better opportunity for you to stay on these and maybe assign somebody from SSI and other Indigenous working groups and ensure that the issues that you've raised are taken care of, and ensure that they can work within the inner workings of your government, as well as the agreements that you have federally, and ensure that they are here territorially. None of these acts will make everybody happy, to be honest. The work that we do as a committee here, we bring it out to the public. We bring light to shed light to these issues. And I strongly recommend that you work with the Inuvialuit, with the Gwich'in and other Indigenous groups to ensure that you stay on that. I'm actually giving advice on that right now. We had a submission from the Inuvialuit Game Council yesterday, and some of the issues that they have, they didn't have any legal staff there, but when we see a turnout like that, we know that they have a direct working relationship. I strongly encourage that you speak with folks from ENR, from the minister to the deputy minister, all the way to the management level, to ensure that you can actually look at some of these amendments that you want, and what could you live, what can you live with, what can you not live with. We all know in the territory that there's land claims groups that have signed agreements and some that don't. But that doesn't mean that we have to sit around and stop this and bring it back. Who knows what it's going to be like the next time around. So, I always kind of work along on some issues like this. It's better the devil you know than the devil you don't. Sometimes when you bring something back like this, it may not be an open working group like this, or the direct negotiations you have with the ministers. So. I strongly believe that things like this could be worked at the last hour when a bill is being drafted. It's never perfect for anybody, but this is the opportunity to move forward and bring the issues that you have to light, and utilize your MLA for the region as well too. I know, being an MLA in the Inuvialuit region, I've been sort of the liaison between the government and the Inuvialuit settlement region. I think sometimes when you need to utilize that and ensure that there's continuity between yourself and the government and the MLAs, sometimes when it gets busy around the territory, here in Nunavik, we had a small turnout yesterday, but it's good to see people here from the community. And I being an Inuvialuit from a land claims agreement myself, I see the direct relationship and how important it is and how key it is to develop those relationships and sometimes stay on them. I don't know if this process that we're going through right now everything has room for improvement. Maybe there will be a different way how these bills are being brought out across the territory and toured and developed from every level and Indigenous governments and the territorial government. So I don't have much to say other than thank you, and continue to work with the minister and the department on these issues. And who knows, you might be sitting there drafting, the terms and conditions with them as well too, as you continue moving forward. Thank you.
Thank you, Mr. Nakamayak, and I believe we have one more, Mr. Testart.
Thank you, Mr. Chair. So I just want to be clear on process, because the legislative process isn't always clear. So the working group's role is over now that it's come to the legislature. So any changes to the bill have to be made by legislative amendment, and they can either come from the minister or from this committee or from any member on the floor of the House when committee of the whole comes up. So there are opportunities to change the bill, but and it certainly would encourage you to work within the technical working group if that's an option and all those kind of things. But to be clear, if this bill passes into law, it becomes a law. And I think for me, why this is a different situation than, say, the Income Tax Act or something like that. There isn't a signed agreement that commits the GNWT to work with Indigenous governments to co-draft legislation. And that's why this is a very different kind of legislation. And if this government's going to really embrace reconciliation, and we've heard that everywhere we've gone, that reconciliation is, this process has been a huge boon to the efforts to reconcile. And not many governments are doing things like this. So this is a really important thing. And I think if we have one bill that sticks out like a sore thumb, we really need to consider whether or not now is the time to do that. And that's where my thinking's at, and I wanted to share that with you. There are two other very significant environmental bills, the Waters Act and the Environmental Protection Act, that have been put off to the 19th Assembly. They were originally committed to be completed this Assembly, but what we have heard is that the parties at the technical working group were too far apart to get those bills forward. When we hear that, and that there was a willingness to move forward, I think we can wait for Bill 44-2 if we can't get it fixed at the committee stage. So, your advocacy tonight is important. Your ongoing advocacy is important. This is not the only opportunity to do that. You mentioned appearing as a witness in committee of the whole. I haven't seen that in my term, but certainly it's well within our rules and something we can discuss. So your message has been heard. There are more opportunities for involvement, and certainly pursue all those avenues. But to be very clear, if this bill, passes through this committee stage, passes through third reading, it becomes the law. And the only opportunities to correct the areas, if they don't get amended into the bill, is the 19th Assembly and a new act to amend the Forest Act. So now is really the time to fix this and to make sure the government's living up to its obligations, its promises that it made when it signed devolution, and its promises to the Indigenous peoples of the Northwest Territories that it was going to do business differently. And that's at the front and center of my mind as I look towards these bills. Thank you.
Thank you. And Mr. McNeely?
Thank you, Mr. Chair. Just to add to my colleague, Mr. Testa, on there, I'll share the same thing I shared at the Clecho presentation the other night in Bichigo. As a result of your claim, the Clecho claim and the Gwich'in claim and the Indivalid claim, which was ahead of ours, there's a lot of similarities in your claim with the other two, because they were created by the territorial Denim Métis claim of 1990. So considering those similarities, maybe there's some similarities that could be approached together. Like if you take lands, for example, which is the next bill after the next coming one, the third one, we're going to be going land in the Clecho area and in the Gwich'in area and Indivalid area and in the Satu area is all the same. You might have more trees in one area, but land is very dear to the owners and to the First Nations community and the non-native community as well. So therefore, that's an example of the similarities. So maybe it just warrants the idea of a joint approach. So I just share that with you, what I shared with the Clecho government. Thank you.
Thank you, Mr. McNeely. So if there are no further comments or questions from committee, once again, Orlina and Charles, thank you very much for your presentation on behalf of SSI. We can really, as you can see, just by even the comments that some members are sharing, that this is a very important time in the history of devolution and then evolving this legislation to work for the Northwest Territories. So we really are grateful for your participation. At this point in time, I'll ask if there are any other members of the public that would like to present today on Bill 38, the Protected Areas Act, Bill 39, the Environmental Rights Act, or Bill 44, the Forest Act. If there's anybody else that would care to comment at this time, if there are none, then If there are no further comments or presentations from the public, then, I just want to, I've been reminded, and I want to remind folks while you're here, and that's going to be for the ITI bills. So we're traveling again on the road to take another bundle of 3 bills out on the road, and that'll be the ITI bills, which is the Mineral Resources Act, the Petroleum Products Act, and the Oil and Gas Act. And we will be here in Norman Wells on May 7th. And so once again, we would look forward to your participation and of course any written submissions that you might want to share in advance on that as well. And so, all right. So if there are no further comments or presentations, if there's no further comments or presentations from the public, do members agree that this agenda item is concluded? Agreed. Thank you. With that, we can be adjourned. Thank you.